Hello and a very warm welcome to the People Stack. So glad you could join us today. We've all heard the stories, maybe even felt that knot in our stomach about employee exits. The confusion over the final pay, the chase for a relieving letter. It often feels like this really messy, uncertain process, but actually it can be quite smooth and, importantly, legally compliant if you just know the steps. Today, we're aiming to cut through all that noise. We want to give you a really clear map for handling employee resignations here in India, turn that maze into a clear path. We've pulled out some genuinely useful nuggets from our sources, so you should walk away feeling much more informed and hopefully confident.
That's absolutely spot on. Understanding these legal duties, it's not just about, dodging penalties. It's fundamentally about building trust, ensuring a respectful transition for everyone, and frankly, protecting your organization's reputation. This is really critical for businesses operating within India's specific legal environment. But before we jump into the details, just a very quick but important disclaimer. The views we share today are purely our opinions. For any specific legal advice tailored to your situation, please consult a qualified lawyer first.
Yeah, that disclaimer really highlights how careful you need to be in this area, doesn't it? I'm actually quite excited to simplify this topic for you today because, let's face it, it often feels wrapped up in dense legal jargon. Our goal is to give you those aha moments without completely bogging you down.
Okay, let's unpack this. So to kick things off, our sources are really clear that the very first step always is the formal written resignation and sorting out the notice period. Why is getting that formal piece of paper, the written resignation, so vital? And what's the deal with the notice period exactly? Well, think of the written resignation letter as the official starting pistol for the whole exit process. It creates a clear, undeniable record. It confirms the employee's intention to leave. Without it, you're leaving yourself open to arguments later about whether someone actually resigned or when or on what terms. So it provides clarity, legal proof. It protects both sides, really. And the notice period, it's absolutely critical that this aligns with what's in the employment contract. If the contract is silent or if there are other rules that apply, then you absolutely must follow the requirements of the specific state's Shops and Establishments Act. This notice period isn't just a suggestion, it sets the precise timeline for everything that follows. It ensures there's time for a proper handover. It's a foundation.
Right, so it's not just ticking a box. It's the cornerstone for making sure everything is legally sound and orderly. You mentioned it sets the timeline. What are some common, maybe, misunderstandings or pitfalls companies run into with that notice period? Like, can you just waive it or pay instead?
That's a really good question. A lot of employers wonder about that, especially if maybe the role isn't seen as critical for that remaining time, or if the employee offers to buy out the period. Generally, the contract will guide this. But yes, both parties can mutually agree to shorten or even waive the notice period. The key word there is mutually. And crucially, this agreement must always be documented in writing. Always. Avoids problems later. Another common thing is garden leave, where you ask the employee to stay home during notice but keep paying them. Again, this needs clear contractual basis or mutual agreement. The main takeaway here is the notice period is there to protect the business, allow knowledge transfer, but also give the employee time, deviating without clear written agreement. That can lead to legal headaches.
Okay, so manage expectations and document everything clearly if you deviate. That makes sense. So once that notice is confirmed, resignation is in hand, the focus shifts naturally to the money, the final settlement. What exactly is the legal timeline for that final paycheck? Because that's understandably a huge concern for any departing employee.
Oh, absolutely. It's a major concern, and the law reflects that. All wages the employee has earned, right up to their very last working day, they must be settled. And here's the really crucial bit on timing. Under the Code on Wages, which consolidates earlier laws like the Payment of Wages Act, that final payment is generally expected within 2 working days after employment ends. 2 working days. It's surprisingly quick. And this time frame isn't just about being prompt, it's a legal requirement designed to prevent disputes and maintain trust during what can be a sensitive time. Honestly, many companies risk non-compliance here, leading to problems they could have avoided. Getting this right is smart. It's good employer branding, too.
2 working days. Wow, that is specific and quite fast. I can see how that might catch some employers out or be tough, especially with the admin involved. Are there common mistakes companies make trying to hit that deadline? Or maybe ways to make sure they meet it consistently?
Yeah, it can definitely be a challenge, particularly for smaller setups without big HR departments or slick systems. A common error is just underestimating the reconciliation needed. Outstanding expense claims, deductions, final leave calculations, things like that. Another mistake is leaving it all until the last minute. Proactive companies. They start the final settlement calculations as soon as the resignation is accepted. They don't wait for the last day. Having a clear checklist, someone designated to manage the offboarding process that helps ensure nothing gets missed. Automation, which maybe we can touch on later, is probably the best strategy. But the key insight from that 2-day rule, it forces employers to be really efficient and organized.
Efficiency is key, definitely. Okay, moving beyond the immediate salary, there's that big long-term benefit that often causes a lot of confusion. Gratuity. This can feel like navigating a maze sometimes. Who actually qualifies for gratuity in India, and how has it worked out?
Gratuity. Yes, it's a significant benefit seen as a reward for long service, for loyalty. Under the Payment of Gratuity Act, 1972, it's mandatory for an establishment to pay it if they have, or have had, 10 or more employees at any point in the previous 12 months. That's the company side. And for the employee, they need to have completed 5 years of continuous service with that company. Now, continuous service is key. Short breaks, like for illness or approved leave, generally don't break that continuity under the law. The calculation itself is fairly straightforward. It's 15 days' wages for each completed year of service. There is a statutory cap on the total amount, though, currently set at 20 lakhs. So while it might seem complex, the rules are quite defined. That 5-year rule means companies need to plan for this liability long term, not just calculate it at the end. It's a key piece of knowledge for employees, too.
All right, so it's not automatic for everyone. But if the company hits the 10-plus employee mark and the individual has done 5 years continuous service, it's mandatory. That clears up a lot. What happens if someone resigns before completing those 5 years? Is there any flexibility, or is it strictly 5 years for eligibility?
For voluntary resignation, yes, the 5-year rule is generally quite strict for getting the full gratuity under the Act. There are specific exceptions where the 5-year condition doesn't apply, for example, sadly, in cases of death or disablement of the employee while in service. But if you resign voluntarily before hitting that 5-year mark, typically you wouldn't be eligible for gratuity under the law. It really does incentivize longer tenure and underlines the purpose of the benefit rewarding sustained loyalty. It's a clear reminder that certain benefits are tied to specific service milestones.
That distinction is really important for everyone to understand right from the start. Okay, changing gears slightly. What about those core Social Security things like Provident Fund PF, the retirement savings, and ESICs, the employee's state insurance for health and Social Security? How are they handled when someone leaves?
These are absolutely fundamental parts of the employee welfare system in India, and employers have very clear duties here. For Provident Fund, or EPF, the employer's main job is ensuring all contributions, both theirs and the employee's, are deposited correctly right up to the last working day. This is vital for the employee's retirement pot. The employee then usually has a choice. They can apply to withdraw the funds, subject to rules, or, more commonly, transfer the balance to their new employer's PF account using their universal account number, the UAN. For ESIC, the employer needs to update their records to show the employee has left and should guide the employee on any procedures for withdrawal, though ESIC is mainly about current coverage. The critical point for employers with both PF and ESIC is meticulous compliance, depositing contributions on time, every time, and giving the employee the info they need to manage their accounts after leaving. Penalties for non-compliance can be pretty severe.
Makes perfect sense. These are long-term funds needing careful closure. Now, what about unused holidays? Any earned leave an employee hasn't taken, is that automatically paid out?
Yes, leave encashment, that's definitely part of the final settlement puzzle. Paying out the balance of any earned leave an employee hasn't used is generally required. This might be mandated by specific state laws, but more often it's governed by the company's own leave policy. Most policies allow for earned leave, sometimes called privileged leave, to be encashed, turned into cash upon resignation or termination. Things like casual leave or sick leave, though, they usually aren't encashable because they're meant for immediate use. It's an important part of the final sum, ensuring people are compensated for accrued time off. Clear communication from HR about the specific company policy here is really key to avoid any confusion.
Okay, so it could depend on the specific company policy for the exact type of leave, but earned leave encashment is definitely something to expect and calculate. Right, let's talk about the final paperwork, the documents. What absolutely must be given to the employee when they leave, for their own records and for compliance.
This is where the documentation becomes absolutely crucial, providing the employee with what they need for their next career step. 3 documents are really essential. First, the relieving letter. This formally confirms they've been released from their duties and states their last working day. It's vital for their next job. Most new employers will ask for it. Without it, onboarding elsewhere can be tricky. Second, The experience certificate. This details their time with the company, the positions they held, maybe a brief outline of responsibilities. It validates their work history. And third, the final settlement statement. This gives a clear, itemized breakdown of everything's salary, benefits paid out, like leave encashment or gratuity, any deductions made. Transparency is key here. These aren't just for the employee. They are critical records for the company's compliance and help prevent disputes later on.
Those sound absolutely essential for a clean break and for the employee moving forward.
Yeah.
Okay, so payments made, documents handed over. Is that it? All done? Or is there one final step for the employer? Maybe something more behind the scenes?
You've hit on a really crucial point. After all the visible steps are done, the final critical step for the employer is meticulous record keeping. All the documents related to the resignation letter itself, proof of final settlement, copies of the relieving and experience letters, even important email communications about the departure all need to be stored securely. This isn't just, good housekeeping. It's essential for meeting statutory requirements and for any future audits. Think about it. If someone comes back later claiming incorrect payment or missing documents, having those records readily available is your proof. It ensures long-term compliance, makes retrieval easy if questions arise, maybe even years later, and supports internal checks. It's the unsung hero of compliance, really.
Okay, record keeping. The silent guardian, as you say. But honestly, listening to all this, it sounds like a lot of detailed, careful work. Especially, I imagine, for small and medium businesses, maybe startups, that don't have huge, dedicated HR teams. It seems easy for errors to slip in or for compliance to get missed. Is there any way to sort of simplify this whole process, make it less of a headache while still being accurate and compliant?
That's an excellent point, and it leads right into where technology can make a massive difference. Our sources mention HR automation platforms specifically designed to tackle this challenge. A platform like, say, Offered can really streamline these processes, particularly for SMEs and startups. How? Well, it can automatically generate things like the resignation acceptance letter, the relieving letter, the experience certificate using pre-approved, legally vetted templates. That cuts out manual drafting errors and saves a huge amount of time. It pulls employee data directly from the system so you avoid those manual entry mistakes that can cause pay issues or compliance problems. It also maintains a digital archive of all the exit documents. Record keeping becomes automatic and secure, ready for audits. And importantly, it can automate tracking of probation periods and tenure. So eligibility for things like gratuity, PF, leave encashment, it calculates that instantly. No more guesswork or delays. It's really about using tech to ensure compliance is seamless, consistent, and provides a much better experience for both the employer and the departing employee. Transforming HR from, a chore to something much smoother. You can actually see how solutions like this work if you look them up, for instance, www.offrd.co.
Wow, okay. So basically it takes all those steps we just walked through, the calculations, the document generation, the record keeping, and automates them, reducing errors, saving time. I can see how that would be a huge help, especially for businesses that are growing fast. So wrapping this up, what does this all mean for you, whether you're on the employer side managing departures or an employee wanting to understand your rights? We've covered the crucial steps. Getting that formal written resignation, sticking to the timeline for final pay, understanding gratuity rules, handling PF and ESIC correctly, dealing with leave encashment, and issuing those essential documents like relieving and experience letters. Plus that vital final step of keeping good records. Getting a handle on these obligations isn't just about following the law. It's the foundation for a smooth, professional, and compliant exit process that respects everyone involved.
Precisely. And I'm going to give you one final thought to leave you with, beyond just the legal compliance aspect. Think about this. How does a transparent, efficient, and well-managed exit process actually contribute to your organization's overall reputation? How might it influence your ability to attract future talent? Because word gets around, good and bad, especially now. A positive offboarding experience can genuinely turn a departing employee into someone who speaks well of your company later. That kind of advocacy, it's incredibly valuable for attracting the best people down the road.
That is a fantastic point to end on. It really shifts the perspective from seeing this as just an administrative task to something much more strategic. Thank you so much for walking us through all of that today, for helping turn what feels complex into a clear, actionable path.
It's always a pleasure. Hope you found it useful. Keep learning, keep applying these insights.
Absolutely. Thanks again for tuning in, everyone. We'll catch you next time right here on The People Stack.